Good evening. This is Selwyn Peters. Part of my practice involves criminal law and litigating also human rights law before the courts in Canada. And recently I had an interesting case, and the case implicated racism, and how the system of justice could be weaponized against black people. And so I want to talk about that a little bit because it's important to deal with this issue and address it frontally. The fact that black people are subject to disparate treatment in our justice system, that black people are pushed out or forced out of jobs, pushed out and forced out of schools, harassed when they're shopping in stores, and treated differently by the police and the justice system is beyond any controversy. And let's make this clear. Historically, false allegations, particularly about black boys or men, either being assaultive, threatening, or even sexual predators, have been reinforced over and over again in Canadian society. Black men are seen as violent, and that they're seen that way is deeply rooted in colonialism, racism, and white supremacy. And most often, black males were accused of any form of violence, including physical, emotional, or sexual violence, are assumed to be guilty instead of innocent until proven guilty. And certainly, I litigated one such case recently in the courts, and that case is representative of that accusing countless other black males who were falsely accused due to issues of racial profiling, white supremacy, and white privilege. So I'm going to go to the transcript right now so that you see the submissions that I made, and those submissions are for the history books, and that's why I'm going to come on live and I'm going to recapitulate them. So my client was involved in a relationship with a white woman, and because she believed he was cheating on her, she made up false allegations against him, got him charged with a whole bunch of offenses, none of which had any merit. So, as part of my closing arguments, I raised the issue of race. And this is what I said to the judge. You have the issue of race in this case because, of course, quite frankly, most of the evidence that certainly debunked the allegations in this case was put forth by the accused. They were not put forth by the complainant, even though it's her case. And he, the accused, is a black man. He gave you evidence. He provided his evidence before you. And then I went on to say that I went on to look at our written submissions, and I said, look, our written submissions quite clearly tells you that you have to take into account race when you're addressing the accused evidence versus the complainant's evidence. The racial context of this case is very, very important because certainly his race and gender are implicated in the charges brought against him. The complainant wanted to criminalize the accused simply because she did not get her way. And, in Morris 2021 ONCA 680, the court said this: "It is beyond doubt that anti-black racism, including overt and systemic anti-black racism, has been and continue to be a reality in Canadian society and in particular the Greater Toronto area. And the reality is reflected in many social institutions, most notably the criminal justice system. And it is equally clear that anti-black racism has a profound and insidious impact on those who must endure it on a daily basis. And anti-black racism must be acknowledged, confronted, mitigated, and ultimately erased." And that was the end of the quote from the Morris case from the Ontario Court of Appeal. I went on to say the only reason I raised Morris is because, look, if we didn't assemble all of this evidence, and thankfully we did, because my goodness, it is chilling that somebody can make all these allegations and all this evidence is there to refute it. If he didn't provide all this evidence, and he testified before you, he said, "Look, I can move people far larger, far heavier than my size. I play football." And it's true. If the complainant had done any of the things this woman said that he did to her, let's be realistic, she would have been severely battered and bruised. She would have been in hospital, and that's not me giving evidence from the lawyer's podium. The complainant gave you that evidence. Not the complainant, the accused, give you that evidence. So, she wasn't assaulted. She was the one that was aggressive, the aggressor in this case at all levels. And her text messages, that video that the accused certainly and thankfully recorded, the FaceTime videos, all of it shows her being the aggressor in all of these circumstances. And we say you have reasonable doubt in this case in respect to all the charges against the accused, and that he must be acquitted on all counts. He must be found not guilty. The complainant, because of her allegations, caused a lot of private and public resources to go into her case. She weaponized the criminal justice system against the accused, and that is part of what racism is. She weaponized the system, and quite frankly, you have these holdings in Morris, you have the holdings in Ontario, and you have these holdings in all these other cases that I cited, because it is hard to imagine the fear that black men experience when they're dealing with these encounters with white people. I'm going to repeat that because I think it's difficult to understand it. It is hard to imagine the fear black men experience when they're dealing with these encounters with white people. And I'm talking about male and female Karens. No one would imagine, unless they're a black male, the sort of fear that black people experience dealing with white people in these encounters, because the system the system believes white people over black people. And I have to put it as bluntly as that, because that's what happened in this case. It's a system that was weaponized against the accused, and that is why we spend so much money to litigate this case. Because we're concerned, and I've addressed it in my submissions, about wrongful convictions. And that is what happens when you have a system of justice or a system of injustice that is systemically racist. You have outcomes that are certainly undesirable, and certainly those outcomes can result in the criminalization of innocent people. Now, we have tons of cases in Canada where people are criminalized and wrongfully or wrongly convicted. The same for the United States, and so it's good in 2022 where you have lawyers who can litigate these cases and frontally raise issues of how race, anti-black racism, and systemic discrimination implicates our system of justice. And so that was the case that I recently did closing arguments on, and we expect a decision to come down in that case very shortly. February 6th is set for judgment, and so we're hoping that the judge sees the case all the way, but we've built a proper factual record to take it all the way, if need be, all the way up to the Supreme Court. So I thought I'd talk about that tonight. I have another case coming up where a black accused shot a white man during a home invasion robbery, where the white guy used a lot of racist slurs and actually planned a racially fueled attack on the black young man. Yet the kid was charged with second-degree murder. So, we have all these failings in our system, and you need the right lawyers with the right schooling and the right critical race thinking to litigate these race-based matters that are the heart of justice, or injustice sometimes.